Well, guys, London News. Good morning, good afternoon, good evening, wherever you are in the world. This is a very short clip. I will stop talking very soon. I'm putting a clip up about the origins of sheriff, and this is specifically for the people in England who are getting sworn in by this guy, the rat catcher or something. No disrespect, at least you're doing something. But you can't have swear sheriffs in without a court. So you get all these people gathering up around a big large tree and other places, and it's just ridiculous, guys, because the system, corporations, which is masquerading as government, they come along and they love it because it has no legal or lawful standing. Not that we care about the legal aspect, but it is definitely not lawful. To have a sheriff, you must be elected by a number of people, 100 preferably, who says, yes, we elect this guy as a sheriff. Then you have to have a court, a common law court. Now, a common law court is made up of grand juries of 23 people. They actually hear a case, have an indictment, or there's no innocent or guilty. It's just an indictment or not indicted, whatever the case may be. Long story. All the information is on my channel. And then you have a jury of 12. So you set up a jury of 12. That elected sheriff takes his oath before that jury and gets sworn in, and each member of that jury signs off on it, a certificate of appointment. I just looked on the wall to see what we had up there. Right, and then that sheriff can elect as many deputies or a posse and elect it. All those people who turn up to stop those evictions can be sworn in as deputy sheriff, like a posse for the day. And of course, their authority only lasts for that particular time within that location. But all this thing of sheriffs, it's a con job. It's disgusting. And I want to help you guys put it together because after all, England is where it all comes from. So have a look at this video that I'm putting up. It's only an abbreviation. I will put the link, and there's heaps of videos and information on it. Remember, common law court, a sheriff elected, sworn in before a jury of 12. That sheriff then elects deputies. They take the oath before a jury of 12 as well. Anyway, further ado, let's go and watch the video, guys. Catch up with you all again soon. London News sign off. Bye for now.
Chapter 1 Origin of the Office of Sheriff. The Office of the Sheriff is one of the oldest offices known to the common law system of jurisprudence. It is an office of great dignity and greater antiquity. Indeed, some legal antiquarians find themselves not contented with antedating the Norman conquest for the establishment of the genesis of the office of sheriff, but profess to find the prototype of the sheriff in the Roman proconsul and that of the earl or count in the consul. This view is founded upon laws of Edward the Confessor, and Lord Coke lent the prestige of his great name, learning, and ability in the favor of this view, but this has been pronounced a mere fancy by Mr. Hargraves. One true it is that in England and all of the American states, the office of sheriff is in existence and is one of great utility and great irresponsibility on the part of the holder of this dignified and ancient office. 2. Origin of the name of sheriff. The word sheriff evolved from the Saxon word ser, signifying shire, meaning county, and the word revate, signifying keeper. The pronunciation or enunciation of these two words combined, developed by a quasi-process of evolution into the modern word sheriff. 3. The origin of the office of constable. It has been asserted that the constable in his dignity of antiquity was an officer, second only to the king. It has been frequently questioned whether the office existed in England prior to the Westminster Statute enacted in the 13th year of the reign of Edward I. However, on the other hand, it has been asserted, with some degree of assurance, that the office of constable in England is of Norman origin, being introduced by William, and that subsequently the duties of the Saxon tithing men, etc., were added to the other functions of this ancient office. 4. Derivation of the name constable. Perhaps the most satisfactory derivation of the name of the office of constable is that which deduces it from the French constable, who was an officer of high honor, great dignity, and antiquity, second only to the king, and this officer is to be found in both England and the United States and perhaps every other jurisdiction administering the common law system of jurisprudence. 5. Origin of the office of coroner. The existence of the office of coroner may be taken up in our day and traced back across the shores of the sands of times until we arrive at a period in an early day of the existence of the early common law, at which point the trace is lost in the mists of antiquity. We do know that under the common law at an early period of the history of that system of jurisprudence, the office of coroner was one analogous to that of sheriff and constable and partook of the dignities surrounding those two ancient officers. The coroner, however, was next to the sheriff in the performance and discharge of his duties and being clothed with the dignity attendant upon that office. Pollock and Maitland say that their origin is traced to an ordinance of 1194. On the other hand, it has been contended that in England, prior and after the time of Blackstone, the office of coroner was one of great dignity, and the office was held by persons of high authority. The office is of equal antiquity with that of the sheriff. 6. Powers and duties of sheriff generally considered. It hardly need be said that the modern office of sheriff carries with it, both in England and in America, all of the common law powers, duties, and responsibilities attendant upon an office of such antiquity and high dignity, except, insofar as the same have been legally modified within the constitutional ambit of legislative enactments. It is not only the power, but the duty, of sheriffs in their various jurisdictions to preserve the peace, enforce the laws, and arrest and commit to jail felons and other infractors of statutory or common law, and to execute all process to him directed and attend up on the trial courts of record, and to preserve peace and quiet, to execute and carry out the mandates, orders, and directions of the courts. He may and is bound ex officio to pursue and take all traitors, murderers, felons, and other misdoers and commit them to jail for safe custody. He is also to defend his country against any of its enemies when they come into the land, and for this purpose, as well as for keeping the peace or pursuing felons, he may command all of the people of his county to attend him, which is called the posse comitatus, or the power of the county, and thus summoned, every person above 15 years old, and in England under the degree of peer, is bound to attend upon warning under pain of fine and imprisonment. It is also in England a contempt against the king's prerogative to neglect to attend the posse comitatus, or power of the county, upon being thereunto required by the sheriff or justices. Differently stated, the powers and duties of the sheriff are analogous to those imposed by law upon peace officers of modern municipalities, exercised by the sheriff in a larger territory, that the lives of the citizens, their persons, property, health, and morals shall be protected and made safe. In the exercise of executive and administrative functions, in conserving the public peace, in vindicating the law, and in preserving the rights of the government, he represents the sovereignty of the state, and he has no superior in his county. When a situation arises calling therefore, it becomes the sheriff's right, and it is his duty, to determine what the public safety and tranquility demand, and to act accordingly. He must, of course, act according to law, but if, holding a felony warrant, he should deem it necessary to take custody of a disturber held by a constable under a misdemeanor warrant, and it is his duty to do so, it is the duty of the constable to yield. In such a situation, the justification of the constable lies in the rightful exercise of overruling authority by the sheriff. 7. Authority of constable. While the office of constable is not of the same grade and dignity as that attributed to the office of sheriff, still perhaps it is a more important office in the immediate vicinity that the officer serves. The duties and administrations of the constable, with reference to the justices or magistrates' courts, corresponds with the duties of the sheriff regarding the trial courts of record. He is a peace officer within the limits prescribed by statutory law of his state, and it is sometimes enacted that this duty or function may be performed anywhere within his county. Differently stated, he is in effect the sheriff so far as concerns any matter within the jurisdiction of the justice of the peace. He serves original, main, and final process, issuing out of these courts. The constable has the same power and is under the same duty to call out the posse comitatus to execute process, and, in this respect, he possesses the same powers and has the same authority within his more limited sphere that the sheriff has in a broader sense and a wider territorial jurisdiction. In short, the constable has all of the powers that appertain to his ancient predecessor under the common law. However, the powers of the constable or other officer are often prescribed by statutory enactments, and out of safety these statutes in each jurisdiction should be examined by the officer called upon to act in pursuance thereof, or by virtue of their provisions. He ought to become perfectly familiar with their terms and provisions. With respect to territorial limitations circumscribing the official functions of the constable, it may be stated generally that, in the absence of a constitutional or statutory grant of authority, he cannot act outside of his own district, precinct, or town in which he was elected. 8. Powers and duties of the coroner. The coroner, as we know him in modern times, is a quasi-judicial officer with the exception when the office of sheriff is vacant or the sheriff is a party litigant in an action and it is necessary or desired to serve him with process, or when the sheriff is disqualified for any other reason recognized by law, or is under suspicion of partiality, or is unable to act on account of illness. In all of these cases, then the coroner may perform the duties of the sheriff, otherwise he acts in a judicial capacity in holding inquests and the like. It is sometimes held that the employment of the word sheriff in statutory enactments or constitutional provisions is in a generic sense and embraces constables or coroners. Likewise, the disqualification of the sheriff, by reason of interest, thereby authorizes the coroner to function in the particular case or instance. It is sufficient to disqualify him even though the sheriff is not a party, but his wife is a party. It is hardly necessary to add that where a sheriff or other officer is disqualified to act by reason of partiality, interest, or otherwise, such disqualification is followed by the far-reaching consequence that all of his deputies are likewise disqualified. This rule is grounded upon the fact that a deputy can only act for, or in the name of, the sheriff or other officer under whom he is a deputy. This rule of disqualification to act in cases of interest, partiality, or other substantial grounds of objection is of so far-reaching effect as to render void the execution of official process by the sheriff, even though there is a statute in the particular state dealing with the matter, but does not in terms prohibit the official performance of such function. A further illustration of the jealousy with which the law guards against a disqualified sheriff or other officer acting is found in those adjudications determining that where the sheriff is disqualified, one of his deputies cannot serve process upon another. At an early date, however, there was a departure from these statutory rules to be found in a few adjudications in the state of New York. But these holdings never gained any foothold without the particular jurisdiction and no substantial recognition within the state of New York itself. 9. The mode of selecting sheriffs. In England, the office of sheriff was bestowed by different processes at different periods in the history of the office. At one time sheriffs were elected, but only freeholders possessed the right of franchise. But later they were appointed by the Crown upon the nomination of the Lord Chancellor, the Treasurer, and the judges. This nomination was made on All Souls' Day, or November 3rd, and not a little importance was attached to the requirements of making the nomination on this particular day. However, in cases of emergency the Crown could appoint a sheriff, thereby dispensing with the process of nominations, and occasionally the king exercised this power without the excuse of urgency or necessity. At an early day in some counties in England the office was hereditary. It seems, too, that the Sheriff of Middlesex was authorized to be appointed by virtue of an authority conferred by the Charter of the City of London. In modern times, it is generally thought that committing the selection of officers to the electorate is the surest method of obtaining faithful performance at the hands of officers, but not so in ancient England. For we are told that the great complaint by reason of extortion and abuse committed by elected sheriffs was assigned as a justification for transferring the appointment of that officer from the election of the people to a nomination by the Chancellor, Treasurer, and judges. It is perhaps true that in every state of the United States, the sheriff is chosen by an election in which the people of the county are entitled to vote. 10. Qualifications of the sheriff. Formerly in England it was requisite that the person appointed to the position of sheriff should, within the preceding year, have partaken of the sacrament in the national church, but this religious requirement was later discarded and there was substituted in its place the exaction that the appointee take an oath that was regarded as of equal binding effect as the Eucharistic qualification. 20 in the United States. However, either by virtue of common law rules, constitutional provisions, or statutory enactments, qualifications are prescribed for the citizen to hold the office of sheriff. A few of these may be mentioned: that he be a qualified elector, a resident of the county for a certain period of time, and in a few jurisdictions the possession of certain property qualifications is an essential prerequisite to being elected to the office of sheriff. Coming to the recognized common law qualifications, it is generally held that citizenship alone is imposed. So, too, an attorney at law is sometimes barred from being elected to, or occupying, the office of sheriff. The sheriff as a judicial officer in England. The sheriff in England formerly, in a very limited capacity, discharged the functions of a judicial officer. It is perhaps safe to say, however, that in the United States this part of his powers, duties, and functions has been entirely abrogated, and he is now exclusively an executive and ministerial officer. Statutes are sometimes encountered providing that where third-party claims are filed as to property that has been seized by virtue of execution or on a writ of attachment, the sheriff may assemble a jury to aid him in the discharge of the duty to determine such claims by third persons, and where these statutory provisions are found and a jury is thus assembled by virtue of the provisions thereof, then in such proceedings the sheriff is a judicial officer and performs the functions of a court. Aside from this isolated instance, the sheriff, both in the United States and England, has been shorn of his judicial power. Most of the functions of the sheriff to act in a judicial capacity were removed by the Magna Carta. 13. Election of sheriffs. We have already had occasion to advert to the mode of selecting sheriffs in England. It may be safely stated that in practically all of the states of the United States the sheriff is elected by the vote of the people. It is perhaps universally required that a sheriff shall take an oath before entering up on the discharge of his duties, and the form of this oath is General Ly found provided for in state statutes and constitutions. Generally in the United States the oath of office required of a sheriff is that he will support the Constitution of the United States and the Constitution and laws of the state wherein he is elected, and will faithfully discharge all of the duties of the office of sheriff to the best of his ability, concluding by calling upon God to help him.